This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's the enemy from within, all the scum that we have to deal with that hate our country. That's a bigger enemy than China and Russia.
Donald Trump has long railed against his perceived enemies from within and vowed to get revenge on a long list of prosecutors, political opponents, and private citizens. And there seems to be little doubt that the president-elect intends to use the Justice Department to exact his revenge.
We will completely overhaul Kamala's corrupt Department of Injustice.
And now Trump is putting together a team of loyalists at the Justice Department that would be positioned to carry out his vows of retribution. Joining me is Stephen Gillers, an ethics professor at NYU Law School. Trump has been very open on the campaign trail about getting revenge against those who supposedly wronged him. And reportedly, some current and former Justice Department and FBI officials are already contacting lawyers in anticipation of being investigated. I mean, do you think that they need to be worried even if they don't think they did anything wrong?
Yeah, they need to be worried because even if they did nothing wrong, and even if they are vindicated in any civil or criminal case that the Justice Department brings against them, the cost of vindication can be enormous in terms of lawyer fees, anxiety, lost time at their job. So, yeah, they should be worried. They should lawyer up. They should take Trump at his word. They should expect to be a subject of investigation. Remember, back in the first Trump administration, there was an IRS investigation of James Comey. Now, that's the IRS, not the Justice Department, but a full IRS audit is time-consuming and expensive. It has been described as the legal equivalent of a colonoscopy. It's very dispiriting to have to go through that. And Comey had to go through that. As it happened, it turned out that the IRS found that he overpaid his taxes. But nonetheless, the cost of getting to that point for Comey in money and anxiety would have been enormous. Well, the same thing can happen in civil or criminal investigations by the Justice Department.
Also, if you investigate someone long and hard enough, you can find other things in their past that may be illegal but not connected to the investigation. Special counsel John Durham conducted years and years of investigations, and the only guilty plea he got was from an FBI lawyer who had lied on some documents. So something not related to the purpose of his investigation.
Right. You know, a thorough investigation can turn up evidence or apparent evidence of wrongdoing, civil or criminal, that wasn't on your radar screen when you started the investigation. When you turn over every document, when you look at every email, you could find things that arguably indicate some basis for a lawsuit or an indictment that you didn't know about at the beginning. But again, you know, if someone is charged with a crime, in fact, or sued civilly, ultimately there's a trial. If there's no settlement, the government can cause a lot of pain without ever having to prove a case at trial just by conducting the investigation. It can bring a case to trial and drop the case. So vindication is not a victory for the target of the government hostility. And conviction or a money judgment is not necessarily the goal of a Justice Department that is out for revenge. The cost in money, time, and anxiety alone can be extremely punishing.
I think we're all aware of one of the people at the top of Trump's enemies list.
Jack Smith should be considered mentally deranged, and he should be thrown out of the country.
Special counsel Jack Smith brought the 2 federal prosecutions against Trump. What kind of investigation or prosecution can we expect of Smith?
Well, Smith is an interesting situation, and from Trump's point of view, judging from what he has said, Smith is Trump enemy number 1. He must be in the president's sights as the dominant person to terrorize with legal remedies and legal threats. Now, anything Jack Smith did to antagonize the president, as Trump saw it, he would have done as an employee of the Justice Department. Jack Smith was in a somewhat different position than other potential alleged enemies. He would have to be defended by the government. That is, a Justice Department lawyer who was accused of wrongdoing after leaving government is entitled to a government defense. There are some exceptions, but if the wrongdoing or the alleged wrongdoing is within the scope of the lawyer's job, the government will defend him. Now, here, that's not possible because it will be the government itself that is targeting Jack Smith. So the Justice Department can't be both the prosecutor and the defense lawyer. And so Jack Smith will have to be provided with the cost of a highly skilled defense law firm to respond to any DOJ effort to investigate or prosecute him. That may be good for Jack Smith in the sense that he doesn't have to pay out of his own pocket. Although even there, I imagine that DOJ might argue that Smith is not entitled to the cost of a defense for some reason that justice comes up with. And then that question has to be litigated, and Smith will need a lawyer to represent him on the question of whether or not the government has to defend him or pay for his defense when the charge comes from the government itself.
So litigation before the litigation.
The local failed district attorney charging a former president of the United States for the first time in history.
What about Manhattan District Attorney Alvin Bragg, who brought the hush money case, the only case against Trump to actually go to trial? Trump has excoriated him, and also New York Attorney General Letitia James, who won that $450 million verdict against Trump.
Well, Bragg and James are also in the Trump target range. Both of them will get a defense from New York State, so neither of them would expect to have to pay out of their own pocket for the cost of a defense. Indeed, the state might defend them through a state agency, or it might pay for private counsel. So that's beneficial for them. They don't have to bankrupt themselves defending themselves. But again, the anxiety and the time commitment of fighting the government can be extremely painful.
I'm trying to think of what kind of prosecution the Justice Department could bring against either one of them. I mean, Trump has said over and over again that they brought these cases for political reasons. That claim failed before the trial judges. I mean, is any of that actionable?
There is no doubt that Trump lawyers, be they public or private, would be able to articulate a remotely plausible theory for targeting James or Bragg, a theory that will fail in court. But all you need to do to get revenge is to conduct the investigation. Now, it is unlikely that the Justice Department will ever represent Trump against Bragg or James. Trump would have to get private counsel to bring those cases. I don't see how the investigations by Bragg and James can be turned into a DOJ case as opposed to a private case brought by Trump himself. He may do that. Another option for Trump, if he wants to get even with Bragg and James, he doesn't have to pursue his own claims. He can just call up any of the relevant regulatory agencies. Of course, the IRS is the most obvious, but surely not the only, to look into their behavior in going after him. And that could be enough to cause them a great deal of anguish, even if nothing comes of it.
I assume out the window is the idea of the Justice Department being nonpartisan and being independent of the White House.
Yeah, at bottom, the problem here is that the Supreme Court has told us that the president controls all power of the executive branch, all of it. That's a direct quote, all of it. And so Trump can control the agenda for DOJ. There's no check and balance within the executive branch. Trump is the decider all by himself about what the executive branch will or will not do in the way of exercise of executive power. So the tradition of norms by which the Justice Department operates independently of the president, that tradition is not legally mandated. And Trump could change it through the Attorney General taking control of the decisions of the Justice Department that are of particular interest to him, by, in effect, taking control of the decisions of the Justice Department that are of particular interest to him. 99.99% of what DOJ does will be of no interest to Trump at all, but a sliver of matters will be of great interest to him because they benefit him or friends of his, or because they target his enemies. And where those matters arise or could arise, Trump is the decider. And so what we've done is flip the switch so that at one time the Attorney General was the decider and the executive, the White House, stayed away from those decisions. Now, for a very small but important sliver of DOJ decisions, the White House will be the decider. And there's nothing that DOJ lawyers can do to resist that. And the ones that Trump has chosen may not wish to resist that.
Trump is going to nominate former Florida Attorney General Pam Bondi to be the U.S. Attorney General. She's a fierce defender of his and has repeated Trump's claims that DOJ's investigations of him were political. He's giving the two lawyers who defended him at the hush money trial top positions at DOJ and naming the lawyer who represented him at the Supreme Court as the U.S. Solicitor General. Does this raise any alarms, or is it concerning?
Yeah, it is concerning because you want people running Justice Department who have no sense of loyalty to the president other than the loyalty of following the law. But there's a personal relationship there. You know, this goes way back to President Kennedy chose his brother to be Attorney General, and there was a lot of criticism of that selection. Well, there's an analogy here. The relationship between Trump and his former defense lawyers could be seen to give rise to a sense of loyalty to Trump that will undermine the need for distance and independence on the part of the people who run justice.
Is there a president in the past who used the Justice Department in the way that Trump seems to want to?
Well, there's some reason to believe that Nixon had his enemies list and did use the department that way. There has never been the kind of overt threats of retaliation against enemies that Trump has prominently anticipated, even during the Nixon years when John Mitchell was Attorney General. We don't have the same degree of evidence of intent in the Nixon-Mitchell years that we have explicitly in Trump's threats.
Thanks so much for being on the show. That's Professor Stephen Gillers of NYU Law School. I'm June Grasso, and you're listening to Bloomberg. On Wednesday, Archegos founder Bill Hwang was sentenced to 18 years in prison for securities fraud and market manipulation. But on Thursday, in a startling twist, the defense attorney convinced the judge to consider reducing that sentence. A jury convicted Hwang in July of 10 charges for orchestrating a scheme to mislead banks into providing Archegos with billions of dollars in trading capacity, inflating the value of his portfolio until the bubble burst in March of 2021, costing banks more than $9 billion. At Wednesday's sentencing, Judge Alvin Hellerstein didn't seem particularly open to the arguments by the defense, even musing at one point that Hwang was a God-fearing man who cheats fellow men. The judge sentenced him to 18 years in prison, very close to the 21 years the government had asked for. But it seems things can change radically overnight. Joining me is Bloomberg legal reporter Chris Dolmesh, who's been in the courtroom for all the twists and turns. Chris, this sentencing was unusual from the start. A 2-day sentencing hearing, and it's not over yet.
So unusual, bizarre, however you want to put it is probably a good descriptor. So the judge had extended the sentencing hearing for a day to address some other issues such as restitution and forfeiture and bail pending appeal. And, that's very unusual in itself because most sentencings take just a couple of hours. But then when they came in on Thursday, Barry Burke, the lawyer for Mr. Hwang, got up and said he had kind of tossed and turned all night and was, just really wondering if they should have done more. And at that point, he proposed changing the sentence, essentially, not giving him less than 18 years in custody, but having the first 11 and a half years be in prison and the second 6.5 years be in home confinement. And the reason he did that is because there's Bureau of Prison Justice Department rules that when you have more than 11 and a half years incarceration, you can't be in a minimum security prison, which he said, would prevent his family from visiting. He's 60 years old. He has heart issues that may require open heart surgery. He was saying, this is the kind of thing that happened during COVID. And it sounds like the judge is considering that. He said he thinks he's allowed to do it. He's not saying he will. The government argued against it, saying they think that would kind of take the oomph out of the sentence, that, they wanted to send a message to others who would commit similar crimes. And they kind of noted that a lot of his crimes were during COVID. So a lot of it was just done sitting around a table in his own apartment. So that's what they're kind of noting. Hey, he's going to be on home confinement. Like, that's not exactly going to stop him from, committing further crimes. So the judge did not decide, but is going to take post-briefing from the two sides by December 5th. And then we'll hold a hearing on December 18th, presumably to address the forfeiture and a possible fine, but that could also be a hearing on whether the sentence is changed at all.
I imagine that Bill Hwang didn't sleep well either. So besides tossing and turning, did the defense attorney have any new arguments for a lower sentence? I mean, different from the ones that they articulated on Wednesday.
Not really. I mean, they rested on their arguments, but they were emphasizing that they don't want to change the sentence. They just think that, being in prison for that much, it's also a much more restrictive facility if he would be in anything above minimum security. So that, it'd be difficult for his family to visit. It'd be difficult for him to get medical care, that sort of thing. So they didn't really expand on their arguments. It was more about his health, the fact that he wouldn't be able to see his family, that sort of thing. The really interesting part to me is that the fact that the judge extended this hearing for a second day essentially gave the defense a window to make this argument. Given this judge's age, they came back fresh and, gave these defense an opportunity to make this argument a little more clearly, and when the judge, was fully engaged in listening to what they had to say.
He is 90 years old. It's amazing that he's still presiding over trials like this, complicated trials like this. So
yeah, it sure is.
The judge asked Hwang's attorneys to submit information on his health status to him privately. But what is he looking for in the papers he's asking both sides to submit?
Essentially, he just wants more arguments on this, and I think he's really trying to flesh out more of the government's arguments against this, and whether he's legally allowed to do it. I think that's what he really wants to know. He wants case law and to know if the law allows him to reduce a sentence he's already given. Another kind of procedural wrinkle to this is that, at the end of every sentencing hearing, when someone gets sentenced, the judge usually signals what he's going to give. He asks the parties, is there a reason I shouldn't impose this sentence? Usually they say no. And then he officially imposes sentence. He asks the defendant to stand up, and he says, you're sentenced to the custody of the Bureau of Prisons for X number of years. He didn't do that. Barry Burke noted that, at the beginning of his kind of argument, and that might have been, some sort of signal to him that he could have made this argument. So the sentence has actually not been officially imposed at this time.
I'm sensing a legal loophole ahead here. And that all goes to what we've been talking about, which is how bizarre the sentencing was, or at least the structure of it.
I'll just add this. It's usually it's folly for a defense attorney to attempt to get up to a federal judge and essentially re-argue their case after the judge's imposed sentence, or re-argue their sentencing recommendation. And with another judge, I don't know if the defense attorney would have done this, because they already kind of irked him with their request for no jail time. And, if it had been another judge, they may have been hesitant to do that. But he's made it clear throughout the trial that, that he's willing to change his mind.
Chris, tell us more about his style, where he interrupts the parties a lot, interjects himself into the proceedings more than most federal judges do.
Right. Judges will spitball all the time during trials and, ask questions of counsel, but they generally prefer to allow the proceedings to happen without their interference. And this judge was not doing that. He was constantly engaging with the lawyers. He was constantly telling them to move on or ask a different question, sometimes just asking their questions for them. So any attempt to make another argument to most judges is met with scorn. And, because they make it clear what their thinking is ahead of any kind of decision, even if they don't tell you what the decision is going to be. They hint at it. And Hellerstein regularly would reconsider things in the middle of the case. And, if he heard a better argument from either side, he would change his mind. And you just don't always see that with federal judges. They tend to believe in their convictions and they stand on their rulings, and they don't really reconsider them unless there's significant new evidence.
Right. They don't want to hear the same arguments over and over again.
Right.
So I've been trying and failing to come up with a sentencing similar to this, where a federal judge considers resentencing the day after the sentence. Of course, as you said, perhaps technically the sentence wasn't imposed. I mean, this isn't like a typical motion to reconsider a sentence.
Yeah, no, that's very true. And, that's a good point, given that, like I said, many of these things are done in a matter of hours. They're not done over 2 days. And judges are pretty quick to adjourn a sentencing hearing if they feel they need more briefing or there are issues they need to resolve before they impose sentence. They want that to be the final say, kind of. It just never really happens like this. I have seen a case where the judge, this was in Connecticut, in a white-collar case involving a bond trader, where the judge did not officially impose sentence that day and postponed hearing for more briefing on, I don't remember if it was restitution, but it was another issue, and then he opposed sentence the next time. But that was a probationary case, so it's not really the same kind of scenario.
And did the prosecutor try to revoke his bail?
No, the government did not oppose having him self-surrender, meaning, he would just report to prison whenever the judge told him to. But they did oppose the bail pending appeal, saying that, this is a significant term of imprisonment and he should serve it soon.
Since the judge granted him bail pending appeal, Hwang will be out through the entire appellate process, which could take years.
Yes, unless, of course, the judge decides to reconsider his decision.
And that's not out of the realm of possibility in this case. Still undecided are the questions of forfeiture and restitution. And they weren't discussed at this latest hearing, right?
Not really. However, I will say this. There were some interesting exchanges about his assets. And the judge noting that, really wondering out loud, whether his assets need to be secured in case of, a final judgment against him that would be combined with a monetary penalty or restitution or forfeiture, whatever have you, because he says he only has $55 million and some of his assets are jointly owned. So the judge wondered whether personal loans should be called back, real estate should be liquidated, whether his residence should be a quote unquote more modest one, whether artwork should be liquidated. But he also noted that any kind of forfeiture, would have to come after restitution, noting that the most important thing is that the victims get paid back first.
So are those issues going to be discussed at the next hearing in December?
Restitution is deferred. It doesn't sound like that's going to be immediately addressed. Forfeiture could be. It's hard to say. It was not entirely clear exactly what they will be putting in those filings, but I think they will probably cover the gamut.
Hwang is going to appeal the verdict. Might one of the grounds for appeal be the judge refusing to allow the defense to argue that the banks were sophisticated financial players who took their own risks?
Basically, that's part of his limiting them from a blame the bank strategy. They weren't going to let them argue in the least bit that the banks were to blame for whatever happened because they gave him too much credit or, allowed him to do these trades without due diligence. That was kind of the thrust of their main argument before it was limited by the judge. It was kind of, you could see this coming even before the trial because this was the subject of numerous discussions before trial and was clearly going to be laid as a path for the appeal.
That's certainly one of the issues that they're going to raise. They certainly raised it in some of their post-trial briefings. In their application for bail pending appeal, they call out some of the expert testimony for the prosecution's expert when she calculated that some of the trading losses were directly attributable to Hwang's conduct or misrepresentations. And they say that can't be proven. So that might be one of the main things for appeal.
A lot more to come in this case. Thanks so much, Chris. That's Bloomberg legal reporter Chris Domesh. Coming up next, why mass tort lawyers are trapped in a cycle of debt. I'm June Grasso, and you're listening to Bloomberg.
Attention veterans who use combat arms earplugs.
Attention cancer victims who use the weed killer Roundup.
Attention women.
Attention landscapers and anyone working in the landscape industry.
If you watch TV, then you've seen all the commercials from law firms looking to sign up plaintiffs who have claims in various mass tort cases.
You and your family may be entitled to substantial compensation.
Compensation. And the compensation for the lawyers can also be substantial. Think about a hefty percentage of payouts that can be in the billions. But mass tort lawyers are facing a double dilemma these days. The payouts on some of the huge cases are taking longer than expected, years longer, and they can't seem to find the next big tort. That means the high-interest loans law firms take out to fund their cases are coming due, forcing them to restructure the loans with pricey concessions to lenders or to refinance with a new lender. Joining me is Bloomberg Law senior reporter Emily Siegel, who's written about this. So, Emily, mass tort lawyers work on a contingency basis, meaning they get a certain percentage of the payout if the case is won or settled, but nothing if it's lost. Explain how they fund these huge cases that go on for years and years.
Sometimes mass tort firms will have their own money that they can put towards cases. But as these cases take longer and longer, litigation funders have come in and sort of like filled this gap for them. So while they wait and they pay all the fees to litigate these cases, they can get funding from a litigation funder. And that has been an increasingly more popular alternative in the mass tort and like plaintiff law space.
I saw that litigation financing is a $15.2 billion industry now. So these are loans with a fixed interest rate that typically mature after 3 or 4 years, rather than being like investments that depend on the outcome of the case.
They're not based on the outcome in the traditional sense of litigation funding, but they do evaluate the case docket before they fund them. So that's how the pricing is based. So they'll look at a law firm's like list of cases, go through them, see what stages they're in. And, you know, some of these mass tort firms have thousands of cases, so they may not be looking at every single one, but they do want to get a sense of them and how far along they are and what torts they're involved in and how diverse it is. And that is how they determine the total amount of the loan. So it does still relate to the actual lawsuits that they're funding.
And the interest rates are high, double digits sometimes?
Yeah, I think because these are high risk, they're often double-digit interest rates, you know, in the teens and 20s. As years go on, the interest rates can go up.
Two of the largest multi-district tort cases are against J&J and Bayer, and they're hitting the 10-year mark with no resolution in sight. Tell us a little about those cases.
Sure. Well, Johnson & Johnson is one of the ones that we often hear about. They've filed for bankruptcy 3 times now to try to resolve these cases. It's just been dragging along. The allegations are their talcum powder caused cancer in its users. So that is the gist of the case. And it has been going on for 10 years. They just filed for bankruptcy again, I think earlier this year. And they have proposed global settlements that haven't been approved yet. So there's a lot of disagreement amongst even the attorneys about whether they should approve the bankruptcy proceedings. It's just become a totally different type of tort because of that. So they're really tied up in the bankruptcy proceedings and the infighting amongst the lawyers. It's just been delayed and there's not really a clear timeline on when it's going to be resolved. So that's one of the main ones. And then another one that it has a sort of a different set of issues is against Bayer for its Roundup product and also causing cancer. And that one, there has been 3 circuits that have had differing opinions on it, which is called a circuit split. So 2 are in one direction and 1 is in the other. So because of that, there can be some delays in dispersing settlements, and it could be something that the Supreme Court has to rule on.
A Supreme Court appeal can certainly take years. Brendan Baer, the founder of Contingency Capital, said there's a degree of stress and distress in the space. Tell us what he meant by that.
So there are 2 things going on, and I think they're related. One is that a lot of these law firms are tied up in these loans that are reaching maturity dates, and there is not a payout yet on the cases that they were expecting to be paid on. So then they refinance their loans, either with the same funder or a different funder, and they have to take concessions when they do that. So that sort of creates this environment of constant refinancing from investors, and the money is not necessarily coming from the cases, it's coming from other investors in the space. And on top of that, there's not another talcum powder right now. There's not another Roundup. There's not another Camp Lejeune. There are lots of mass torts that are going on, but there's not this like gigantic one that they're all looking towards or that's farther along. So there are two things going on in that the firms are refinancing rates more often than they expected to be. And also there's not this big tort that everyone is putting their money towards. Or at least, a lot of these law firms are really excited about and think, could be helpful to their clients, but also result in a big payout.
I found that fascinating that as they're litigating these cases, they're looking for the next big tort that they can go after.
Yes. I mean, they always are, I think, to some extent. And there was one, I believe it was last year, that was against Tylenol, alleging that Tylenol, when taken by a pregnant person, would cause autism and ADHD. And it ended up going to a Daubert hearing, which, would test the science of the claims, and it failed. So that was one that I think some had thought could be the next big one, because a lot of women take Tylenol when pregnant. It's approved, and it could have been a really massive group of people. But then since it failed, it did not become a multi-district litigation. And that was something, not everyone, I think there was some skepticism around it, but they were intrigued by that one. And so there isn't something like that. I mean, one of the ones that's referenced in the piece is Depo-Provera, which is a contraceptive injection. And that is one that they think will be like a big tort because there are a lot of injuries. But, I haven't heard of others at this point.
Yeah, one of the financiers told you that there might be 7 major mass torts at the moment. And once those are settled or litigated, there could be 3 to 5 years with no actions. And some of the experienced mass tort lawyers are blaming the new players and firms in the space, saying they're borrowing a lot of capital and fueling the heavily leveraged environment. One told you the market has blown up exponentially. So they're blaming the new guys.
I think so. I think that some of the mass tort or some of the plaintiffs' attorneys believe that there are other law firms that are entering the space because they want to get rich. And they want to build up their case book, and the way they want to do that is through litigation funding. So they get all these cases, they use the money to market and put out commercials, they retain a lot of different claimants, and then they have to work up those cases, and they're not really, at least this is what those attorneys are saying, they're not really prepared for the work that goes into working up each individual case. So if you're a law firm of 2 people and you have thousands of cases because of your litigation funding, how do you attend to all of those clients? So that's what they are saying, that there's just a lot of new firms, not necessarily new lawyers, but new to the space coming in and wanting to be part of this. And it's creating an environment where there's a lot of lending going on and also making it more crowded.
So it's a difficult area of litigation. It takes a lot of money. It takes a lot of time. But if you win, are the rewards for lawyers, would you say, astronomical?
It can be. I think it depends on the quality of the cases that you have. Quality meaning the injuries within like the defined realm for the MDL, and if you have a lot of cases like that, a lot of these mass tort lawyers are quite wealthy. So yes, but it's also not easy to find good cases and to work them up. So I think there's that sort of tension going on right now.
Let's say the inexperienced lawyers or the lawyers that are new to this field have a lot of clients. They benefit if there's a settlement, right? Sort of riding on the coattails of the more experienced lead lawyers?
They could be. It sort of depends on what they're putting their money towards, right? So if they get a lot of funding and they put it towards marketing, but they hire a marketing company that's not doing a great job vetting calls as they come in, you could end up with thousands of cases that are not very valuable. Or you can do your research, you can put them towards marketing with companies that you trust, and you can be working them up as they're coming in. And there's just different approaches. But I think the concern is that some of these firms may have lots of cases that actually don't qualify for the tort. Maybe, like, for instance, if we talk about Camp Lejeune, which I wrote a piece on this last year, some of the law firms had clients who were fake, like they gave them a fake address. They just wanted to get in on potential settlement because they see these advertisements. So I think, yes, they could be a big part of the settlement, but their cases still have to qualify. They still have to have used the product and been injured by it in a specific way.
And is there any concern that the lawyers are thinking about their investors and their investment before their clients' concerns?
Some attorneys believe that that is the case. It's hard to know really what's going on behind closed doors, but there have been allegations of that, in particular in the Johnson & Johnson talcum powder cases. There have been law firms accusing other law firms of wanting to accept the bankruptcy proposal, but then only because they're motivated by having to pay back their loans to the investors. So that's definitely alleged a lot. Whether it's actually happening is hard to say. But I know that a lot of lawyers are concerned that that's happening.
Are there firms that have decided to get away from mass torts because of the length of time involved in these cases?
I think that there are some, at least on the funding side, there are litigation funders that try to have a more diverse portfolio. So if they're going to invest in firms that have mass torts, they also want those firms to be handling other personal injury cases, because those are shorter term and, that can sort of keep money coming in while they wait on these big torts. I think that as they enter this period where they're looking for another tort, they're just looking for firms that are really aware of that and are just trying to be as diverse as possible. There are many funders who don't do mass torts at all because they do not like the duration issues. What I heard from Andrew at Esquire Bank, he saw this happening years ago and thought, I need to move farther away from this while still having some money exposure in mass torts, but also the smaller single cases.
Well, your story is really fascinating, Emily. Thanks so much. That's Emily Siegel, Bloomberg Law Senior Reporter.
And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.